Good morning, friends and colleagues, and welcome to the Family Law Roundup, May 2024. My name is Mervyn Vermeulen. I'm an attorney, and I'm going to be taking you through what I think are the interesting and noteworthy developments in May 2024 in terms of family law in the South African context. I see that some of our folks are struggling to log in to the meeting, so I'm going to just take care of a little bit of admin whilst everyone gets their logins sorted out, and then we will start jumping in to the case law roundup for this month. So, folks, we have quite a few interesting judgments to take care of today. We've got about 25 to go through, so I'm going to be working at a eminently brisk pace this morning as we go through the family law roundup. So let's get into our formal plugs while we get started. For those of you who would like to have a look at some of our resources, please visit ThinkLegal.co.za. There you can register for events, you can join our WhatsApp groups, purchase resources, and view past webinars. Very importantly, if you would like to get hold of the course material for today's session, please go to thinklegal.co.za or visit our Shopify store. Nadia will share the details of our Shopify store with you shortly. There you can purchase the bundle of decided cases. We are looking at 25 judgments today. Our summaries look like this, setting out exactly what you need to know about the case to get fast-tracked into it. It is approximately 30 pages of summaries, and then this month quite a lot in terms of the bundle. We're looking at about 400 odd pages of recent case law emanating from South Africa. So what is ThinkLegal? ThinkLegal is legal knowledge open to everyone. It's an initiative by Vermeulen attorneys which aims to promote the open sharing of sound legal knowledge. While we acknowledge that the delivery of legal services is for the most part a commercial venture, we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. For this reason, we do quite a lot of work within the community to open dialogue, share legal knowledge, and host events. I'm just going to ask Nadia just to share the links for StreamYard and YouTube to the various groups and social media. I'm getting quite a few emails from people that are saying they are struggling to join via the StreamYard link. I hope that we'll be able to share the YouTube link for them to follow us there. Thank goodness for Nadia, otherwise I would be in hot water. But I see there is a fair whack of us already in the room, so I am looking forward to talking to everyone, and I'm going to keep going so that those who need to catch up later in the recording can do so. So, ThinkLegal, supported by Lawbox Practice Management Software for lawyers by lawyers. You can try Lawbox free for 14 days by going to lawbox.co.za, and then obviously also supported by Vermeulen attorneys. So, without any further ado, folks, let's get into the roundup. As mentioned, I've got 25 matters to run through. I am going at an extremely brisk pace today. Please also, as a disclaimer, understand that this is not case law for lazies. I'm going to show you where to start looking, but to get a proper view of each of the cases that we are going to be going through, it is obviously incredibly important that you read the case yourself. In spending 90 seconds to 120 seconds on a case is not going to give you the full essence. It's just going to give you a nice starting point to get fast-tracked. So today we are starting off with a matter relating to burial rights. The matter is Makatsi versus Metele and another. That is from the Eastern Cape High Court in Bishu. And this is under the pen of Hartle J. For those of you following along in your bundles and summaries, this can be found at page 1. Now, what happened here is there was a dispute between the applicant and the first respondent over who should have the authority to bury the deceased. Now, the applicant was the estranged spouse of the deceased, and she contended that she should bury him as his surviving spouse. She was supported by their children. The first respondent was the deceased's son, who had also initiated burial arrangements. In this instance, the applicant approached the court to get the authority to attend to the burial over the deceased. What was interesting in this matter is that the court found that a fairness approach should be adopted and that each case is to be decided on the merits of its own particular circumstances. The outcome was that the applicant, the estranged spouse, the wife, was essentially vested with the sole authority over the mortal remains of the deceased. Now, I found two quite interesting quotes from this judgment. Both of the quotes are up on your screen. To the contrary, fairness in this particular fact scenario dictates, in my opinion, that the applicant, rather than the first respondent, should bury the deceased in keeping with the family's joint discretion, which supports their mother taking the lead in this respect and burying their father at his ancestral home. That's paragraph 8. And then paragraph 32 of the judgment, as was stated closer to home in Mahala versus Nkumbumbini and another, in circumstances like these, there should be no hard and fast rules, and each case is to be decided on its own particular circumstances. I like this. Common sense should be the order of the day, and the approach to strive for is one of fairness in the particular circumstances of the case. For those of you who would like to have the full citation, Makatsi versus Metela and another, 389-2024, and that's 2024 ZAEC BHC 11, and that was 18th of May 2024 under the pen of Hartle J in the Eastern Cape High Court, Bishu. Right, that was our first judgment, and we are well and truly into it. Next up, folks, I have a few care and contact judgments for you. I think we've got about 4 care and contact judgments, all the way from KwaZulu-Natal, Johannesburg, Pretoria, and then circling back to Johannesburg. So let's jump into our care and contact judgments. The first one, PD and another versus AR and another, which was a very, very interesting judgment from the KwaZulu-Natal High Court under the pen of Mossop J. You can find the judgment in your bundle at page 12 and the summary at page 2, the full citation, PD and another versus AR and another, D779-2023, and that is 2024 ZAKZ DHC 27. This judgment landing on the 17th of May 2024. Now, this is an interesting matter in that it dealt with an urgent application for care and contact by an interested party. Now, essentially, what gave rise to the litigation was that the applicants had an informal arrangement with the biological parents of a minor child who was aged 5 at the time, where they had the child in their care. The informal arrangement came to an end. The respondents, being the biological parents, terminated the arrangements, prompting the applicants then to approach the court on an urgent basis to try to establish care and contact with the child, who was, as I mentioned, 5 at the time. The aspects covered under this judgment range from the rights and responsibilities of caregivers. Now, remembering caregivers is a concept which is defined in the Children's Act. And what was also interesting in this fact is that in this court was the fact that the court did not follow the family advocate's recommendation. So for those of you dealing with matters where you have a family advocate's recommendation which you do not believe to be in the best interests of minor children, this judgment could give you some precedent, especially if you are in the KZN area. And then the essential fulcrum of this matter was that parents have the responsibility and right to regulate who their children exercise contact with. The court dismissed the application of the caregivers, ruling that the applicants had no legal entitlement to contact with the child. Furthermore, the urgency was, there was not found to be any urgency in this instance. Two notable quotes, paragraphs 26 and 20 of the judgment. First one, paragraph 26, parents are entitled to regulate the lives of their children. They may determine with whom their children have contact and on what terms. And then paragraph 20, the applicants have no entitlement in law. It is not their duty to explain to the minor child why the arrangement no longer prevails. It is the function of her parents. Very, very important judgment insofar as we do see quite a lot of these Section 23 and 24 matters coming up recently with third-party caregivers wanting to establish formalized contact and care arrangements. Those of you who were in the roundup last month would remember that there was that interesting Cape Town judgment with the surrogacy arrangements where there was care and contact put in place. Right, that was PD and another versus AR and another, all the way from KwaZulu-Natal under the pen of Mossop J, and that judgment landed on the 17th of May 2024. Incidentally, folks, as we go on, please do feel free to interact in our chat bar if you are on StreamYard, or in the comments if you're on YouTube or on LinkedIn. It is great to hear from you. Please tell me whether you agree with the judgment, don't agree with the judgment, and what you found interesting about the judgment. I really do appreciate the feedback. Moving swiftly along, we are back in Johannesburg on the 17th of May 2024. This judgment, GW versus MH, landed under the pen of Todd AJ, and that was bundle page 25 for those of you who are following along in our resource bundle, and the summary is on page 2 of your summaries. This is PD and another versus AR. Sorry, my apologies. GW versus MH 2023 120036 2024 ZAGPJHC 467, and that is the Safley reference. Now, what happened in GW versus MH is a dispute between unmarried parents over the applicant's right to overnight contact with a 2-year-old daughter. The parents had previously managed their parental responsibilities and rights amicably, but some disagreements arose over sleepover contact as well as financial support. The court was approached to provide interim relief to include sleepovers with the child. The respondent opposed it, citing concerns for the child's well-being. Now, the issues raised in this matter, obviously, as in the case of all contact and care issues, Section 28(2) of the Constitution and Section 7 of the Children's Act, obviously being that the best interests of the child are paramount. The court also held that the courts must adopt a balanced, child-centered approach which should be informed by constitutional values and should be sensitive to culture and religion. In this instance, the applicant's request for overnight contact was deferred until the appointed psychologist provided a report on the best interests, the court obviously taking a conservative approach and erring on the side of caution. In the interim, the child was to reside with the respondent, and the applicant would have specified contact times without overnight stays. Costs for the psychologist would be borne by the applicant, and the applicant was ordered to pay 50% of the respondent's costs to date. The notable quotes from this judgment, I had 3 that I found, 2 of which are on your screen. The third one is on the next slide. The best interests of the child are paramount. The court must take into account the considerations set out in Section 7 of the Children's Act, and the court should adopt a child-centered, balanced approach informed by constitutional values and sensitive towards culture and religion. Nice quote for heads of argument in terms of setting out the approach to be adopted. That's paragraph 12. And then paragraph 17 being the turning point really of the ratio of the court. I'm unable on the evidence before me to reach the conclusion that it is in fact in the best interests of the child to have sleepover contact with the applicant at this point in time, before the parties have received the benefit of the expert advice and assistance of their chosen psychologist on this question. And then finally, interesting one in terms of dispute resolution. It is certainly regrettable that the parties have found themselves unable to reach agreement on these things. They have many years of co-parenting ahead of them, during which I have little doubt it would be in the best interests of the child if her parents are able to conduct their arrangements in a consensual manner and are not in conflict about them. Obviously, very, very much an approach that adopts Section 6.4 of the Children's Act, that there must be a problem-solving and a non-confrontational approach, and certainly sensible advice to all parents of small children embroiled in litigation. That was, folks, GW versus MH, all the way from Johannesburg on 17th of May, under the pen of Todd A.J. Next up, LT versus CT, and now we are going up to the North Gauteng High Court, and this citation, LT versus CT 31058 of 2020, and that is 2024 ZAGPPHC 486 from the North Gauteng High Court, and that was under the pen of Vannerskyf J. For those following along in our bundle and our summaries, you can go to page 34 of your bundle and page 3 of your summaries. Now, what happened in LT versus CT? There was interim contact and care was at play. There were sexual abuse allegations, and then contact and care had been separated for determination post-divorce. Now, this was quite interesting, I found. There were protracted divorce proceedings with a lot of contentious issues regarding the care and contact of 2 minor children. There were allegations of sexual abuse by the father, which led to a forensic and clinical assessments to determine the best interim arrangements for the children's welfare. The issues dealt with in this matter: best interests of the child, obviously Section 7 of the Children's Act, Section 28.2 of the Constitution. It looks at the approach taken by the court in interim care arrangements. It deals with how forensic assessments are dealt with in cases of alleged abuse. It deals with issues of supervised contact pending investigation, and then also the issue of equitable cost sharing for assessments. What happened in this instance is the assessments were ordered and interim care and contact arrangements were set in place. 2 notable quotes from this judgment. Paragraph 12, not really apropos of the ratio of the court. However, very interesting to see the court's view. The evidence before the court indicates that both parents purposely or through indiscreet conversations with others in their presence exposed the children to conflict and their respective views and distrust of the other parent. The parents have also not yet mastered the skill of civilized communication, a fact attested to by Dr. Stoker's recommendation that handovers of the children take place at the school to minimize contact. And then the court's supplication to the parties. The parties are again implored not to involve the children in their disputes with each other and not to discuss each other or the litigation with the children or within earshot of the children. They are urged to act reasonably, and this obviously being a very good example of a case which flared up in a very, very significant manner. That is LT versus CT from Pretoria High Court under the pen of Van der Schuyf J on the 31st of May. Right, making very, very good time, folks. The next judgment we're going to look at, ED versus HG. HD, not HG, apologies, ED versus HD. That's quite a tongue twister. 2023 107780, 2024 ZAGPJHC 499. That being quite a tongue twister in its own right. This is from the South Gauteng High Court and the judgment under the pen of Goodenough AJ, bundle page 43, summary page 4. Quite an interesting judgment to read in terms of procedure and appeal procedure. What had happened here? So there was interim care and contact pending application for leave to appeal is the little head note I put in, and there were allegations of sexual abuse by a half brother of the child. So what you need to know about this judgment is there was a very convoluted history of orders from inter alia, the Children's Court, Domestic Violence Court, and the High Court. The applicant approached the court to reinstate a former order of Besaid Note AJ on 19th of January 2023, pending the appeal or review of an order granted by Mayor AJ on 9 April 2024. Now, I've put this in the summary, specifically just the dates of the orders, because reading the judgment, I have to be honest, I had to read it about 3 times just to understand the chronology of what happened and why it happened. Not something the court could be castigated on. It is a very convoluted and complex turn of events, but I've kind of distilled it down just to make it easier to understand. So essentially, there was an order by Besaid Note AJ on the 19th of January 2023. Then there was another order by Mayor AJ on the 9th of April 2024, just over a year later. On that matter, one of the parties launched an application for leave to appeal. That had not yet been heard. So that party then approached the court to say, I want to go back to the Besaid Note order pending the leave to appeal, and this landing before Goodenough AJ having to make sense of everything that was going on there. What the court dealt with in this instance was the best interest of the child, obviously, Section 7 of the Children's Act, Section 28(2) of the Constitution, and the importance of stability and continuity for the children, avoiding unnecessary upheavals, and the procedural impropriety of unilaterally interpreting court orders and the need for adherence to court protocols in appeal processes. Now, we know that execution pending appeal is a problematic thing, and it is often the hotbed of quite a lot of hurdy-gurdy when it comes to litigation. Application was essentially dismissed. Costs were reserved. The court had some strong words for the parties in the judgment, but very interesting judgment. The court saying, look, I'm not going to step too much on Mayor AJ's toes. I'm going to dismiss this application. Costs must be dealt with during the leave to appeal argument by Mayor AJ. And what the court was leaning towards in this matter, in my view, very interestingly, was preserving continuity and stability for the children and avoiding upheaval. And that seems to be where the ratio of the court came from. The practical effect of the order sought would be that the children would now immediately, 6 days before the hearing of the application for leave to appeal, be removed from Mr. D's care and their current school in Paris, be returned to Mrs. D's care and be re-enrolled in their previous school. This would result in 2 major upheavals in the space of 5 weeks, which the court would essentially not want to do. And obviously, taking into account it was a mere 6 days before hearing of the application for leave to appeal. So 6 days in the grander scheme of things was what the order related to. Were I now to make an order directing the immediate return of the children to Mrs., I would be overstepping my powers. In my view, it is not for me, but rather for Mayor AJ in the course of adjudicating the application for leave to appeal to decide, if so requested, the question of whether the implementation of her existing order should be stayed pending the outcome of the application for leave to appeal. Very interesting procedural aspects to deal with here, and very important to note the view of the court and the approach of the court in preserving the continuity and stability for the children as far as possible. That was ED versus HD, all the way from Johannesburg, under the pen of Good Enough AJ, bundle page 43, summary page 4. Next up, we're going into the issue of customary marriages, and we're going to start off with BS versus PM in the Johannesburg High Court. This is an appeal judgment. The judge Van Vieren AJ, penning the judgment Lamini J, concurring. For those following along in your bundles and on your summaries, it's bundle page 52, summary page 5. And the citation, I'm not going to give the case number again. It just becomes too much of a tongue twister. It's 2024 ZAGPJHC 508 is your SAFLI reference. And this is BS versus PM. Now, what happened in BS versus PM was that the appellant, Mrs. S or Ms. S, appealed against the decision of the Randburg Regional Court, which granted absolution from the instance at the end of her case in a dispute regarding the existence of a Tsonga customary marriage with Mr. M. Now, it's a very interesting factual matrix in this case, and I would urge you to read the whole factual matrix and the ratio of the court. The aspects looked at, customary law must be applied by the courts when applicable, subject to the Constitution and any relevant legislation. That's obviously in terms of the Customary Marriages Act. Compliance with Section 3.1 of the Recognition of Customary Marriages Act is essential for the validity of a customary marriage, and for a valid further customary marriage under Tsonga law, spousal consent is required. Mr. in this instance was previously married. There was some controversy over whether it was disclosed to Ms. in this instance, and it was quite interesting to see how the court dealt with it. A notable quote was referring to MM versus MN in another 2013 for SA 415 Constitutional Court, which was essentially the final word on the issue. And paragraph 51 of the judgment, the court refers to MM versus MN. In the majority judgments penned by Froneman J, Kampepe J, and Squiggia J, the Constitutional Court concluded that Tsonga customary law had to be developed to include a requirement that consent of the first wife is necessary for the validity of a subsequent customary marriage. The court's reasoning included that this conclusion is in accordance with the demands of human dignity and equality. The court in BS versus PM, following that judgment and finding that the consent of the first wife was necessary and essentially upholding the decision of the Randburg Magistrates Court, to allow absolution from the instance. So no valid customary marriage in this instance, because under Tonga customary law, it was necessary to prove spousal consent by the prospective husband's existing wife, which was not given. I can imagine a very awkward conversation between Mr. and his existing wife when she found out that he had purported to enter into a further customary marriage. That is BS versus PM, Johannesburg High Court, and that is under the pen of Van Vuren AJ with Dlamini J concurring. Next up, folks, we go over to a very interesting judgment on divorce, all the way from the Constitutional Court. Now, very important in this judgment, we have a divided Constitutional Court, which I will tell you about shortly. The citation ZACC 9 is our SAFLI reference, 2024 ZACC 9. This is from the 22nd of May, 2024, and is obviously now the final word on the subject matter. That's bundle page 73, summary page 6. Now, importantly, we had a very divided Constitutional Court here. Tron J penned the majority judgment, concurring with Tron J's Collipin J, Matopo J, Rogers J, Cheeky J, and Van Sale AJ. The minority judgment was penned by Skippers AJ, but Zondo, Chief Justice, and Maya, Deputy Chief Justice, concurring. So we have essentially a 3-6 split in terms of this, but with the Chief Justice and the Deputy Chief Justice following the minority. Oh, thank you. I got some coffee. Yippee. Now I can go on. With the Chief Justice and the Deputy Chief Justice concurring with the minority judgment. So what happened in DHB? Now, this was a very interesting judgment, which I think is going to be quite relevant in a couple of matters. And it dealt with a prenuptial contract. And I say prenuptial contract because it is separate from the antenuptial contract. It dealt with the issue of maintenance and with pacta sunt servanda, which I will deal with shortly. So the case concerned the enforceability of a prenuptial agreement providing for maintenance on dissolution of the marriage. In addition to this prenup, the parties had an antenuptial contract, which is distinguishable, wherein they excluded community of property and the accrual system. So first they had the antenuptial contract. Then they entered into this prenuptial agreement, which included provisions for donations and maintenance upon death or divorce. This matter then went through the regional court first. It had a huge, long drive through the court system, making sojourns from the regional court to the High Court, from the High Court to the SCA, and from the SCA to the Constitutional Court. So there's a long history of interesting and often contradictory findings. The regional court upheld the enforceability of the prenup. So it said, look, the antenuptial contract, great, out and out, but there is this prenup, so we are enforcing this prenup with the donations and the maintenance. High Court came along and reversed it, saying that the prenup contradicted the antenuptial contract and undermined the provisions of the Divorce Act, specifically Section 7.2. The Supreme Court of Appeal then reversed the High Court's decision and followed what the regional court said in terms of upholding the prenup and finding it to be valid. The Constitutional Court, having the final word, dismissed the appeal from the SCA, affirming that the prenup is enforceable and does not conflict with the antenuptial contract or the Divorce Act. So it is possible to have a further prenuptial contract aside from the antenuptial contract, which regulates the matrimonial property regime of the parties. Obviously, I'm assuming a very, very chuffed regional court magistrate in this instance, having been exonerated, as it were, by the Constitutional Court, basically finding that the judgment was sound. Now, a lot of instances of different factors considered in this matter. Number one is pacta sunt servanda, the principle that agreements must be kept, people must be held to their agreements. The Concord looked at freedom of contract. Parties can structure their agreements as they see fit within legal bounds. It looks at donation agreements. The court found that the donations in terms of the prenup did not alter the matrimonial regime stante matrimonio, and they can coexist in harmony with antenuptial contracts. And then further, it looked at the Divorce Act, Section 7 thereof, and that these agreements are not contrary to Section 7. The Constitutional Court found that the appeal is to be dismissed with costs. Section 7.2, i.e. spousal maintenance, in terms of the Divorce Act, is a separate issue capable of determination unfettered by the judgments. And I want to be very, very clear that the Constitutional Court, in its judgment, made it very, very direct and clear to the parties that the law, or the rights that they have in law, so the cold in Johannesburg made me seize up for a second. The parties still have their remedies in terms of law, in terms of Section 7.2 and the antenuptial contract. The prenup is a separate issue that was dealt with. Now, the quote from this, our notable quote on the question that was before the regional court, the SCA held that having regard to the definition and purpose, including the primary objective of the two legal instruments, these instruments could coexist. This is because the ANC contract regulated the matrimonial regime, stante matrimonio, whereas the prenup had no bearing at all on the nature of the matrimonial regime and the respective estates of the parties. Their estates remained separate. Thus, the provisions of the ANC would remain intact and would be applicable upon the divorce, despite the respondent's entitlement to enforce the terms of the prenup. Now, this is very, very interesting. Also, consider the minority judgment of Schippers AJ, also quite persuasively written, and as I mentioned, the Chief Justice and Deputy Chief Justice both aligning themselves with the minority judgment. When you read this judgment, obviously the majority judgment is the binding one. However, the minority judgment may still also have some persuasive effect in terms of dealing with the subject matter in future. That was the judgment of DHB versus CSB, and that is Constitutional Court, and that is ZACC 9. That's interesting. Section 6 of the Maintenance Act provides any written or verbal agreement regarding maintenance is enforceable, so we'll be able to enforce the prenup in maintenance courts. Yeah, absolutely. I'm quite sure that that will be the case. Now, what is quite interesting, it will then be beyond the forum that the parties approach. If there is a divorce, we would probably see it in the Rule 58 or the Rule 43 courts, whilst there's a stante matrimonio kind of position that the parties are still married pending the divorce, and then finally at the divorce courts. But very interesting point. I think that you would certainly be able to rely on these types of agreements in the maintenance courts. Right, next up, we are going all the way down to the Eastern Cape High Court in Mthatha in the judgment of VG versus TM. And this is also an appeal from the regional court under ZAECM HC 39, 30 May 2024, and that is under the pen of Hinana AJ, bundle page 115, summary page 8, for those of you who are following along. The issue in this matter, as we see at least one or two of these judgments every month, forfeiture of patrimonial benefits, Section 9.1 of the Divorce Act, an appeal from the regional court. The parties were married in 1991. in community of property, separated in 2022 and divorced in 2023. There was a forfeiture order granted by the regional court. The appellant challenged the regional magistrate's order and argued that there was no substantial misconduct to justify such forfeiture. Now, as we know, substantial misconduct is one of three factors that may rise to a forfeiture order, the others being the factors or the circumstances which gave rise to the breakdown of the marriage and the duration of the marriage. Those three aspects are looked at cumulatively, and the court must then frame a picture of whether there will be a undue benefit to one of the parties if the forfeiture is not granted. In this instance, the court also looked at contribution of the parties. And folks, this is something which I think is very, very ripe for case law to be made on, because more and more we are seeing the courts look at contribution when contribution is not necessarily a factor that is contained in section 9.1 under misconduct, circumstances, and duration. And I think incorrectly so, because I think contribution of the parties is patently relevant. So it's going to be interesting to see how this develops in coming months or years. In this instance, the appeal was upheld and forfeiture then failed. There was a division of the joint estate. Now, guys, remember, forfeiture is a heck of a fact-specific issue. It is something that we have to look at in terms of the facts and the merits of each particular matter. Notable quote is paragraph 17. Regional magistrate identified inter alia the fact that the appellant had children out of wedlock and the effect that his actions had on the respondent's health as factors that put a strain on the marriage. Those are factors that led to the breakdown of the marriage, but they do not, according to evidence, constitute sufficient basis to warrant forfeiture of benefits flowing from the marriage regime. It is common cause between the parties that they were planning to build the marital home and they apportioned financial responsibilities in that the appellant bought bricks and the respondent bought iron sheets. Both parties contributed, therefore forfeiture failed. VG versus TM, and that is from the Eastern Cape High Court under appeal under the pen on Hinana AJ. Next up, we're going all the way north to Limpopo, and let me see how we're doing on time. We've got a whole wad to go through, so I'm going to up the speed a bit. We're about halfway through in terms of time. VG versus TM, that was the forfeiture matter that we just dealt with. Going on to MR versus MT, that's from Limpopo High Court, ZALMP PHC 45, 6th of May 2024, under the pen of Kanyago J. That is bundle page 123, summary page 9. What happened in MR versus MT is the following. I found this judgment particularly interesting. There was an antenuptial contract signed by the parties after customary rights and prior to civil marriage. The court was called upon to determine the validity of the customary marriage. It was an appeal from the regional court. Now, if there was a customary marriage that came into being before the antenuptial contract, the parties would have been married in community of property. If there was no a customary marriage, the parties were married in accordance with the ANC, and this then became a point of some serious contention. The appellant sought a final decree of divorce claiming no division of the joint estate due to the marriage being out of community of property with an ANC which excluded the accrual out and out. The respondent contested the validity of the ANC, asserting a prior customary marriage. The court, the regional court, ruled in favor of the respondent, declaring the ANC invalid and granting an equal division of the joint estate. The appellant appealed, arguing the ANC's validity and asserting that it complied with legal requirements. Now, the question which was the basis of all this controversy was whether a customary marriage came into being. It follows. If there was a customary marriage, ANC invalid in community. If there was no customary marriage, ANC valid out and out. The court looked at the provisions of Section 3.1 of the Customary Marriages Act And it was very interesting on what basis the court found that there was no antenuptial, or there was no customary marriage. The parties at all times, according to the testimony, intended to enter into a civil marriage. The court essentially says that even though they did the customary rites, they did what they thought was the correct thing culturally, but they intended to have a civil marriage. So, in terms of Section 3.1 of the Customary Marriage Act, remember, we have three requirements. The requirements are, number one, that the parties must be above the age of 18. They must both consent to be married under customary marriage, and the marriage must be negotiated and entered into. Very often we focus into the marriage being celebrated and entered into, because that's the complex part of it. That's where you need to establish what's the culture that's applicable there, or what is the customary law system that is applicable. The court threw a curveball, and the court actually looked at the middle issue. The parties must both consent to be married to each other under customary law. And what happened here was the court said no, the parties did not. They intended to marry in terms of civil law. That's why they did the civil marriage. So the appellant and the respondent had determined their MPR as per the signed ANC. The court takes judicial notice that in black culture it is normal for the parties to first negotiate lobola and finalize those negotiations before they go to conclude the civil marriage in church or at home affairs. When they go to church or home affairs to conclude their civil marriage, it does not mean that they are changing their matrimonial regime from customary to civil. What it entails is that the parties have first observed their custom before concluding the civil marriage. It is also common in black culture for lobola negotiations to take some years before they are formally concluded. It is therefore not surprising that the parties commenced their lobola negotiations on 25 July 2009, but then only concluded their civil marriage on 27 January 2015. The court being turned on the court's view that the parties, having intended to enter into a civil marriage, did not consent to be married to each other under customary law. Very interesting judgment from Limpopo, and it's going to be interesting to see how the other divisions interpret this. Very, very clearly stated by the court under the pen of Khanyago J. Bundle page 123, summary page 9, ZALMP PHC 45. Very interesting judgment to take note of for those of you working in customary law. Next up, we go to Pretoria again, and this is an older judgment, but I've put it in because it has now been reported. MM versus OM 2024 3SA 133 GP, Pretoria High Court, under the pen of Mabuse J. Bundle page 133 and summary page 10. The question came before the court as a stated case in terms of Rule 33 of the Uniform Rules, and the court was asked to adjudicate essentially whether pension benefits which were received by a member spouse who ceased to be a member after institution but before finalization of divorce and received only after finalization are capable of division in a joint estate. What happened was the following. The one spouse was a bit naughty, resigned and retired. I think it was 2 days after being served with divorce summons, thinking that that would clear out their pension benefits. So they resigned from the fund. However, the divorce was then finalized on the 21st of July, and the pension payout only received in October of 2017. The member spouse essentially said, well, it's not part of my estate. The other spouse said, well, Section 7.7 of the Divorce Act says that your pension interests are to be deemed an asset, and that must be capable of division. So the question in the stated case of the court was, can a former member spouse who has ceased to be a member of a pension scheme before finalization of divorce, but who received his or her retirement benefits after divorce, be ordered to pay such a portion of such benefits that accrued to him or her during the divorce to the former non-member spouse? The court, I quite like the approach of the court. This court takes it that it is not a general question, but a question that relates particularly to the facts of this case. The judge made quite a lot of points in the judgment of saying, I'm not here to give you legal advice. I'm adjudicating on this case. The simple answer to the question is yes. The facts of the party's case show that their case is a quintessential example of such a case where a member spouse who ceased to be a member of a pension fund before the finalization of a divorce, but who received the benefits of his or her retirement after divorce, may be forced to pay a portion of such benefits to a non-member spouse. So in those instances where we see people resigning quickly from their pension funds in anticipation of a divorce, take note of this judgment. Next up, we go to Malebane versus Jordan NO and another 2024 3 SA 124 GP under the pen of Lagrancy AJ, bundle page 148 and summaries page 12. Now, this one also a bit of an older judgment, but only having reached the SA law reports in this last edition. The issues involved here is whether an adjustment can be effected by a liquidator after divorce. The applicant wanted the liquidator to be removed from the division of the joint estate following divorce. The applicant alleged bias and overreach. And then the court had to consider whether the liquidator's actions were justified and within their powers, as provided for by the MPA and the divorce settlement agreement. The court looked at section 15.9b of the MPA, and it also looked at the Actio Poliana Utilis, which it says was the basis of section 15.9 adjustment claims. Now, folks, 15.9 essentially being if you are married in community of property and you enter into a prohibited transaction and the joint estate suffers loss, you can be ordered to adjust to make right with your spouse on divorce. So if the joint estate suffers loss of 50 Rand due to a loan entered into, for example, you would have to compensate your spouse by 25 Rand in their favor so that they don't bear that 50% of the loss. And the court's ratio was the words by die verdeling van die gemeenskaplike boedel should be widely interpreted to mean in the process of the division of the joint estates, which starts with a decree of divorce and which ends after actual distribution. Thus, in this instance, because the court order made provision for it, the liquidator having the power to effect those adjustments in terms of section 15.9. Right, next up, we're going to something quite interesting, domestic violence. We're seeing more and more domestic violence judgments coming out on appeal to the High Court. This one, once again, from the Limpopo High Court. This was, I'm going to give you the judgment fully now, the citation. It is GD versus NB. My apology, folks, just an error there on my slide. GD versus NB, ZA LMP PHC 51, 20th of May 2024. Now, what happened in GD is it was an appeal against a final protection order, which was granted by the Domestic Violence Court. The appellant was the husband of the respondent's sister. So the respondent was the complainant in the DV proceedings. The appellant said that there was no domestic relationship under the DV Act, arguing that the magistrate was incorrect, and also arguing Plascon Evans, which we'll deal with shortly. The appellant essentially said, well, I'm not related by consanguinity. I'm essentially the brother-in-law of the complainant, so it's not a domestic relationship. The court had to decide whether it was a domestic relationship, number one. Number two, it had to apply the Plascon Evans rule when dealing with final interdicts. And it also looked at the interpretation of domestic violence, including psychological and economic abuse. Interesting read for those of you who do a lot of DV. The court upheld the final protection order, citing that there was a domestic relationship by affinity and that there was sufficient evidence of domestic violence. So Brother-in-laws, sister-in-laws are considered to be domestic relationship under the Domestic Violence Act. The DVA was clearly enacted to accommodate the growing number of domestic violence incidents and to rectify the shortcomings of the Prevention of Family Violence Act 113 of 93. In fact, one aspect governed more extensively in terms of DVA is the categories of persons who can apply for a protection order. In this regard, the DVA provides an extensive definition of a domestic relationship. All the way from Limpopo, that is the judgment of GD versus NB on domestic violence. Next up, we are going to the Hague Convention again. This is from South Gauteng High Court, and this is quite an interesting judgment under the pen of Crutchfield J. That is on bundle page 197, summary page 14. Central Authority for the Republic of South Africa and another versus M and another ZAGP JHC 458. As in most of the cases where we see the Hague Convention applied, the fulcrum was Article 13b, grave risk of harm under the convention, which is one of the justifications for a child not to be returned to the former country in terms of the Hague Convention. So this was an application by the Central Authority for RSA. Obviously, as we know, this is the family advocate, and the minor child's father seeking the return of the minor child to Australia. The mother opposes the application, citing a grave risk of psychological harm to the child, and the court then addresses whether the child was wrongfully retained and if an exception under Article 13b of the convention applies. Now, we know this happens in the wake of the Constitutional Court judgment where the child was eventually ordered to return to the United Kingdom, preceding of which we had a whole line of cases refusing the return under Article 13b. Now, in this case, the court returned the child, rejecting the Article 13b argument which was put up by the mother. The convention is quite clear. Unless an Article 13b exception, i.e. a grave risk of harm, is established, the child must be returned to the country of their habitual residence, if it is a treaty country, obviously, or a convention country. The burden of proving the Article 13b exception lies with the party opposing the return, in this case, the mother. The mother must prove that there is a grave risk of harm, and the court looks at the threshold. It must be a grave risk of harm. The threshold is very, very high. 117 of the judgment says the threshold for meeting the exception in Article 13b is high. The level of risk alluded to by the respondent in the founding affidavit in the report of Ms. Keeve, who was the expert, does not rise to the standard of a serious nature required by the exception and does not reach the degree of seriousness of risk of harm or the harm itself envisaged in the convention. The emotional harm that is contemplated by the article must rise to the level equivalent to an intolerable situation. The facts and evidence before me do not meet the threshold in terms of Article 13b. Paragraph 118, the very next paragraph. The alleged harm relied upon by the respondent in the event of the return of the minor to Australia is that described by the Constitutional Court in paragraph 63. It is harm that is inherent in the inevitable disruption, uncertainty, and anxiety which follows on an unwelcome return to the jurisdiction of a child's home country. In the circumstances, the alleged risk of harm does not warrant the description of grave risk. And there is no real or grave risk that the minor, upon return to Australia, will be exposed to harm or that the level of risk is grave. Now, incidentally, we know that there are a lot of forums taking place, notably later this month in Pretoria, the forum on the Hague Convention and obviously protective measures, because we know that in a lot of instances, the Hague Convention has been utilized by spouses or parents in instances where abuse was present. Now, that is going to be very interesting to see the upshot of that. But for now, Central Authority for the RSA and another versus M and another, following the Constitutional Court and Crutchfield J ordering the return of the child to Australia. Next up, we go into harassment. Now, this is quite an interesting one from the Free State High Court, B versus K, and that is under the pen of Van Sale J, ZAFS HC 145, page 224 bundle, summary, page 15. Now, what happened in B versus K is that the one party threatened the party with contempt proceedings arising from a contact order post-divorce. The applicant sought an interdict alleging harassment, intimidation, and abuse by the respondent through WhatsApp messages and threats of contempt proceedings. So what happened here was the applicant residing abroad with the child was allegedly frustrating the contact of the respondent. The respondent obviously getting very irate, saying, I'm going to take you on for contempt, you're going to land at OR Tambo, they're going to arrest you, etc., etc. And I'm horrendously paraphrasing. The applicant, who's the mother, who is the one allegedly frustrating contact, approached the court in the Free State and said she wanted an interdict. A rule nisi was issued giving an interdict, and this was now the return date of the rule nisi. The rule nisi was discharged by the court, and the court looked at what constitutes harassment, and it also looked at the issue of jurisdiction over children in cross-border matters. So it's quite interesting to see that. The court's ratio set out in section 50, or paragraph, not section, paragraph 54 of the judgment. The applicant bemoans the fact that the respondent, open quote, threatens, close quote, her with contempt of court proceedings, that she will be arrested when she arrives in SA, etc., and states that she feels intimidated and harassed thereby. However, the so-called threats are all lawful remedies, which the applicant has at his disposal to compel the applicant to comply with the divorce order. There is absolutely nothing wrong with telling the applicant that he will use his remedies should she not comply with the divorce order. To the contrary, it is clearly indicative thereof that the respondent is of no intention to take the law into his own hands. I know that we often see in practice parties post-divorce sending horrendous WhatsApps to one another to say to them that I am going to take you on for contempt of court. I want contact, you are in contempt, and. So this is going to be a very interesting judgment as far as that is concerned. That is the judgment of B versus K, Free State High Court 145, and that is under the pen of Van Sale J. Next up, we go to maintenance. Before I go into our formal maintenance matters, there is one that kind of snuck in last minute, RS versus JS 2024 ZA Western Cape High Court 154 under Lekuleni J. I'm going to be looking at it fully in next month's roundup because it landed on the 3rd of June only after I'd already prepared this one or this session. However, it is very important for you to take note of it. I know that it also went out today on the Spartan case law update. For those of you who are not involved with Spartan, go look at Spartan case law. They do a wonderful case law service, and Louis and Soyon are lovely people to work with, and they are doing a wonderful job of keeping us all informed. Obviously not forgetting Pren, who also works with them. This matter, RS versus JS, will deal with fully. Essentially what happens in this matter, there is a legal duty to maintain in an instance where there is a de facto adopted child, where the adoption was not finalized and the child's best interests being the defining factor. Very interesting judgment on Spartan. I see Jennifer agreeing with me. Spartan is absolutely fantastic. I don't get paid by them, by the way, folks. I just think it's a phenomenal service, and it costs like $1.5 a year. Really, it is worth it, giving up some of your spending money to get these fabulous updates from Spartan. So go and have a look at RS versus JS. For those of you who are on the WhatsApp groups, make a plan to go and have a look. I know Dion, who was involved in that matter, shared the judgment. Great outcome for the child in this instance. Well done to the teams who were involved in bringing this very important matter before the Western Cape High Court. We will deal with it in more detail next month. So, moving on with our May matters, first off, versus WCK, that is ZAGP PHC 438. This is the North Gauteng High Court. Now, this was an interesting matter. It was an urgent application for maintenance pending maintenance court adjudication. The parties were divorced and they had a severely disabled son, MC, who suffered from autism spectrum disorder and a severe intellectual disability. The child was residing in a care facility and the mother was facing serious arrears with the facility's payments due to the father essentially pleading poverty. The court had to decide whether the father should be ordered to contribute equally to the costs until the maintenance court could review and make a final order. The matter landed before Neukircher J in the North Gauteng High Court, and she rendered her judgment on the 2nd of May 2024. The judgment is on page 259 of your bundle and on page 16 of your summaries. In short, the court looked at the best interest of the child, looked at urgency, the court looked at the parties' equal responsibility, and it also looked at the Children's Act sections 162F, 71I, and 111A in addressing the special needs of this child. The respondent was then ordered to pay 50% of the arrears and 50% of future fees pending a maintenance inquiry, and the applicant was ordered to approach the maintenance court within 14 days. And the parties were ordered to attend mediation. However, importantly, folks, this was done by consent. I got very, very excited when I saw that there was mediation ordered, but it was done by consent. The court stating the imperative of the High Court sitting as upper guardian is to ensure that the best interest of the child is at the forefront of every application in which their best interest is considered. It's all the more important when viewed against the backdrop of Section 28(2) of the Constitution and Section 9 of the Children's Act. I'm of the view that this application is urgent by the simple reason that I'm dealing with a severely disabled child who requires full-time care. So the court made an interim order pending the adjudication of the maintenance court. Very interesting, and I think a very significant judgment in terms of emergency situations such as this, where the child was being faced with being put out of the sanctuary where they were residing, and the mom then being faced with a position where she would have to stop working to look after the child. This is very interesting. 29, I almost omitted to mention this this quote. In my view, in order for the provisions of the Act to hold any true meaning, both parties are required to share equally in the responsibility of ensuring that they prioritize the needs of their children. And this is even more so in circumstances such as the present. This goes far beyond financial sacrifices that parents make every day. Every day in this country, thousands of parents, grandparents, and family members sacrifice their own comforts to ensure a better future for their children entrusted to their care. So much more in a situation such as this. In my view, this is the only way that the provisions of the Children's Act hold any true meaning. Very profound judgment under the pen of Neukircher J from the Pretoria High Court. Folks, just a reminder for those who joined us late, go to thinklegal.coza to go and register for events, join WhatsApp group, purchase resources, and view past webinars. Nadia and I are hoping to put up our big training for the second half of this year in the next day or two. It will probably be a second running of our Divorce 101, which we have would be running now for the second time, which we are polishing up and should be a nice 3-evening session on the ins and outs of divorce. For those of you who would like to purchase the resources for today's session as well, please go to thinklegal.co or go to our Shopify store. Remember, if you get the resources, you get our 30-odd pages of summaries, our 450-odd pages of case law, which we've taken for you from we got online and put into a paginated bundle. And then also, if you are a mediator under SAAM, SAM, or SJAM, social justice, then you get a nice juicy 2 CPD points for attending today's session and getting the summaries to utilize in your practice. Next up, we go to a very interesting yet disturbing matter from KZN on the issue of privacy, that is CEA versus MB under the pen of Mossop J, which was interdictory relief sought by the applicant against the respondent who accessed and recorded private footage of the applicant having a sexual encounter without her consent. The footage was later shown to third parties, severely compromising the applicant's right to privacy. The court had to determine the appropriate remedies and sanctions. The court took a very heavy-handed approach against the respondent, quite rightly so. It looked at the constitutional right to privacy, Section 14 of the Constitution, protection against unlawful intrusion and dissemination of private information, and it also looked at the unacceptable nature of the respondent's conduct and the necessity of punitive measures in terms of a costs order on attorney-client scale. The respondent was interdicted from publishing, disseminating, or disclosing the video showing the sexual encounter. He was also ordered to pay the costs of the applicant on an attorney-client scale. Very important judgment in terms of the right to privacy in the more acrimonious matters where we know sometimes clients take action which is very unsound, and this is definitely a cautionary tale to litigants. Court saying at paragraph 38, the respondent's logic is unsound. He previously acknowledged that the house at which the applicant resided had previously been the matrimonial home. It was no longer. It was no longer his home, and he had no rights to it. He had no right whatsoever to inspect the contents of the hard drive. The fact that his clothes were in that house, as he alleges, and that his son lived there, endowed him with no right to do any of the things he did. This one I put in obviously because we know that very often when one spouse unthinkingly vacates the matrimonial home, they get a little bit of a bee in their bonnet of wanting to go back into the house. And this is obviously a nice reality checking situation. Next up, we go on to AT Born M versus SCT and another. That is the East London High Court, ZAECE LLC 18. This matter under the pen of Zono AJ. My apologies, I'm trying to do too many things at once and I'm cognizant of our time running out. Bundle page 294, summary page 19. And what this dealt with was extreme urgency by which the applicant sought a preservation order over pension fund until the finalization of the proceedings in the Makanda High Court. The court saying a lot about the conduct of the applicant in terms of urgency and the requirements for an interdict. For interim interdict, the application was dismissed, and the court dealing obviously with self-created urgency in paragraph 11. It's well established that the applicant cannot create its own urgency by simply waiting until the normal rules could not be applied. However, what happened here was that the issue of urgency wasn't considered alone. The court actually heard argument and then decided to dispose of the matter in its entirety, and that was the dismissal of the matter. Moving on, in terms of procedure, I go into DA versus DTM, which deals with the writ of execution. That is before Green AJ in the South Gauteng High Court, ZAGPJHC 416, bundle page 306, and summaries page 20. This dealt with a writ which was issued concerning post-divorce maintenance payments. There was a settlement agreement, and the respondent then went and issued a writ claiming unpaid maintenance, including significant costs for stabling of a horse. The applicant contested the writ on the grounds of compliance with the settlement agreement. The court essentially had to determine whether stabling was envisaged in the settlement agreement. So it was basically an interpretation issue. The court considered the principles in the Indomani and University of Johannesburg cases. The court looked at an objective interpretation and did not look too much at the subjective intentions, and the clauses should be interpreted to avoid insensible and unbusinesslike outcomes. The court set aside the writ, concluding that the stabling costs did not fall within the ambit of maintenance obligations. Very interestingly, the court made a lot of comment on the affidavit, and this, I think, is a cautionary tale for us as legal practitioners. The tone adopted in the papers and the correspondence were exchanged. While parties who were previously married to each other have lost their love and affection for one another and may even harbor animosity to each other, that ought to be put aside when the interests of a child born in the marriage are considered. Resort to allegations of ulterior motives, mala fides, and the employment of emotive and adjectival language in correspondence and affidavits does little to progress issues and reach a sensible resolution. Very important point that Joe raises. I'm going to quickly show it to you guys. Remember, any CPD points recognized by one NABFAM member organization will be accepted by all of them. That is KZN, Society of Mediators, FAMAC, SOM, and Social Justice. So if you're a member of any of these organizations, CPD points from this webinar will count towards your continued accreditation. Absolutely, if you are under one of the NABFAM bodies, those CPDs will count. However, I am still very keen and I am busy trying to get all of these guys accredited through the other NABFAM bodies as well. So hopefully soon everyone will be able to get a certificate with their organization on it. But thank you, Joe, for making that point. I really, really do appreciate it. Right. So DA versus DTM, bit of a cautionary tale in terms of how lawyers address one another in affidavits and correspondence. The general approach to interpreting contracts set out in paragraph 15 worth a read in terms of interpretation of settlement agreements. Right, next up, LZ versus IZ. This was also under the pen of Good Enough AJ, and this was in the South Gauteng High Court on 21 May 2024. Bundle page 316, summary page 22, LZ versus IZ, ZAGPJH C509. What happened here? It was the applicant wife urgent application seeking interim maintenance from the respondent due to lack of support for herself and the children, pending the finalization of Rule 43. So the Rule 43 had been launched and the set down was pending. An urgent application was launched on the basis that the applicant said that she and the party's children are starving. The court had to address the emergency situation where the children were reportedly starving due to respondents' non-payment. The court said quite a bit on the procedural issues. It dealt with the obligation of parties to file FDFs. The court looked at why the parties hadn't filed FDFs. However, the court also was cognizant of the duty of the court as upper guardian of minor children to ensure their welfare, overriding procedural shortcomings. The court's discretion under urgent circumstances was to grant interim relief. The court made an order that the respondent pay, I think, $7,500 a month, and this was just so that there was immediate relief. There were also directions given for timely uploading documents to case lines to facilitate the Rule 43, and the court very pointedly stating, had it not been for the fact that the present application deals with the allegations that the party's children are starving, I would have struck the application from the roll. Someone asked whether the CPDs are for ADR register. I believe it's the ADR International Register, not at this stage. It is something that I will consider if there is enough need for it. If anyone would like me to approach them for CPDs as well, please pop me a mail and I will, if there is enough demand, I will get in touch with them. Right, next up, and we are almost out of time, 10 minutes, folks. So I'm going to go at a lightning pace through the last ones. As I mentioned, 25 judgments. We've got 6 to go, and I'm going to fly through them. All the way to the Western Cape on appeal. Hofmeyr AJ with Montame J concurring. CC versus DGC ZAWCHC 204. What happened here was the jurisdiction of the regional court was in question. The one party sued, the other party counterclaimed and included a counterclaim for 1.7 million rand, which obviously excludes the monetary jurisdiction of the regional court, being at last estimate, I think it was 400,000, but I'm a bit rusty on that. I'm more into the family law now. Someone please correct me if I'm wrong on the monetary jurisdiction of the regional court. Remember, in terms of section 29(1) capital B of the Madge Court Act, the Madge Court or the regional court has the same powers as the High Court in matters arising from divorce. The question in this case was whether the 1.7 million rand claim arose from divorce. The court found that it did not. It was remote from the divorce. The court finding that the real issue is not that the counterclaim was for an amount of 1.7 bar, but rather whether that counterclaim qualifies as a question arising from divorce. This one, just to poke a little bit at the magistrates who I see are in today, and a lot of love that I have for you. The High Court saying the Madge Courts are creatures of statute without inherent jurisdiction. It is Parliament that defines the limits of their jurisdiction. And please do not hate me forever for poking at you folks in this instance. Right, now, the court then went on at paragraph 18 to say, in enacting the amendment to the Madge Court Act, the legislature did not simply provide that the regional court would hear divorce actions. It employed language to extend the scope to include questions arising from divorce. The language chosen signals two things. First, it denotes the regional court's jurisdiction is broader than simply deciding divorce actions. Second, it sets an outer limit to that extension because it constrains the jurisdiction to questions arising therefrom. The phrase any question arising therefrom forges a link or a connection between the subject of divorces and the questions associated with it. In other words, in terms of monetary jurisdiction, shoot for the moon as long as it is from it arises. Oh, I'm already getting the first one. Helen, sorry about that. I'm going to get another one just now, I see. But lots of respect and lots of love for our magistrates. And thank you also for being a part of our community and uplifting us and conversing with us. Next up, we've got an interesting relocation case from the Western Cape High Court. This was ELB versus AVM. My vocal cords getting very, very fatigued now. ELB versus AVM, ZAWCHC 132, 14 May 2024, under the pen of Mtimunye AJ. That's page 334 of 23. Now, what happened here was it was not leave to relocate that was sought in this instance. It was an urgent application to return minor children to Johannesburg and investigate their best interests. The court addressed issues of urgency and procedural compliance. It looked at Rule 612 of the Uniform Rules of Courts, looked obviously at the best interests of the child in relocation disputes, and then the procedural requirements of compliance with the practice directives, which I think was interesting from Mtimunye AJ, dealing with the non-compliance of the practice directive, because very often litigants think that the minute there are children involved, the rules go out the window. And the court in this instance took quite a hard line. The ratio of the judgment not necessarily based on just that, but applications struck from the roll, lack of urgency, each party to pay their own costs, and a very interesting quote at paragraph 40 on the practice directives of the division. I'm going to leave it there, lest we run out of time to go on to our next one, VL versus FN, Judge Solly's judgment, which obviously made the press. VL versus FN, as yet unreported. I haven't been able to find it on Safely. I managed to get hold of it from another repository. So no SAFLI reference yet, but it is in the bundle for those who have decided to purchase the bundle. That is on 348 of the bundle, page 24 of the summaries. Final stretch, 4 more to go. Will be done just after 12:30, I think. What happened here? It was the applicant sought the court's leave to relocate to Germany. Respondent opposed the application. Obviously, the court had to determine what was in the best interest of the child. There was expert reports in this instance, and very importantly, the court relied extensively on what the expert told them, and the court actually very poignantly referred to what the child said, and we'll deal with that shortly. It looked at the best interests of the child. It looked at the fact that applications must be made in good faith and must be reasonable, and then obviously that the child's views and wishes must be considered. Child in this instance was 12. He had a voice, was a very, very bright lad. In the most salient words were, however, expressed by none other than the minor party's 12-year-old son, the judge writes at paragraph 2, whom forms the subject of this application, that this son said, "It's going to be a loss for one of the parents and a loss for me, no matter what." And I think as litigants who consider these types of relocation matters, because they are a reality and they are becoming increasingly prevalent as South Africans become more globalized, we must bear in mind this very, very profound set of words from this 12-year-old child. It's going to be a loss for one of my parents and a loss for me, no matter what. And hopefully we can help our clients to have some sensitivity for what their children go through in these instances. The relocation was granted. At the end of the day, I'm satisfied that the applicant had duly and sufficiently addressed the concerns in considerable detail, and the requirements have been adequately ventilated and addressed. And the court basically said, look, it's a bad situation no matter which way you swing it, but it is in the best interests of the child. The best of a bad situation is to allow the relocation. Finally, folks, we have 4 Rule 43s to go through. First one is going to be 3 Rule 43s. First one, YY versus GY, all the way back up to Johannesburg, under the pen of Mohammed AJ, page 371 of your bundle, page 25 of your summaries, ZAGPJHC 439. Now, what happened in YY versus GY? It was an interim contribution to legal costs and maintenance. The applicant alleges that there was infidelity, etc., etc. Respondent challenged the financial management and expenditure claims of the applicant. The principles looked at was that the applicant must demonstrate a need for maintenance and the respondent's ability to pay, which I've found a bit problematic because this is in respect of child maintenance and not spousal maintenance. I'm not sure where the need for maintenance requirement came in. The court considered the children's best interest, parties' financial disclosures, and proportionality in maintenance. The determination of interim maintenance should balance with the actual needs of the children with the parties' respective financial capacities, which I agree with. Interim maintenance was ordered, contribution to costs was dismissed in this instance, and then paragraph 18, as I say, the applicant must demonstrate a need for maintenance and the respondent's ability to pay the maintenance, which I think we must just be very, very clear that this does not mean that you first have to prove a need of the children. If the one party has sufficient money, it doesn't mean that the other party is off the hook necessarily. Section 18 of the Children's Act makes it very clear that maintenance is an obligation of both parties. Right. Moving swiftly along for the sake of time, EW versus SW. This is Van Aswegen AJ, Johannesburg High Court, ZAGPJHC 465, page 383 of the bundle, page 26 of your summaries. And this was a Rule 43.6 based on an alleged change in circumstances that the court had to deal with. There was a previous Rule 43 order. The court found that there was no change in circumstances and the application was dismissed. And it looked quite intensely at the issue of non-disclosure at paragraphs 95 to 100. In not making a full and frank disclosure, the applicant has affected the adjudication in this matter. Critical for an applicant in a Rule 43.6 to act with the utmost good faith, going back to Dupria, obviously, which is one of our which is a locus classicus in terms of disclosure in Rule 43. And then the applicant had the onus of satisfying the court that her circumstances were not prevailing. And due to non-disclosure, amongst other things, obviously the application was dismissed. Interesting, the court saw through the applicant's strategy. It's apparent that the applicant deployed a litigation stratagem of non-disclosure or selective disclosure of a true financial position since the first 43 application, which traveled through the second Rule 43 and now the current application. Then last but certainly not least, folks, with 1 minute to go before I release you and myself back into the wild, MN versus ALN, ZAGP PHC 402, once again a judgment under the pen of Neukircher J in Pretoria, bundle page 409, summary page 28. The facts of this matter, application where the applicant sought maintenance and arrears or retrospective or retroactive maintenance from the respondent. For those on the WhatsApp groups, obviously, there was quite an interesting discussion on that point yesterday on retroactive versus arrear maintenance. The court found that the applicant's maintenance claims were excessive and not commensurate with the party's means. Application was dismissed as an abusive process. What is very interesting, folks, paragraph 1 to 2, Judge Neukircher talking about the length of the papers. It seems that since the full bench decision that we had in Johannesburg some years back, that Rule 43s have become big standalone applications, and Judge Neukircher being very clear that, that's not the intent of the rule. The FDF was brought in to obviate the need for lengthy affidavits. And here we see 160 pages plus 90 pages plus an amended notice of motion plus another 133 pages of heads plus another 265 pages, and essentially landing up with far in excess of 600 pages for the poor judge to read in dealing with a Rule 43. The judge essentially finding that the Rule 43 was an abuse of process and the application being dismissed. Folks, that's it from the Family Law Roundup, May 2024. Thank you so much to all of you who joined us live while I presented this roundup. Thank you so much to those of you who purchased our course pack. As I mentioned, it is completely voluntary, but it does make it worthwhile for me and Nadia to do this monthly, because I assure you this roundup takes the best part of 2 to 3 days to prepare every month. So a good way to support us and to keep it feasible for us is to purchase our bundles and our summaries, $250. You can buy it all the way on Shopify. Go to thinklegal.co.za. You can buy this month and all of the previous months of 2024, the roundup, and then also get yourself a nice juicy 2 CPD points. For those of you who aren't on our WhatsApp groups yet, where are you? Come join the conversation. Go to thinklegal.co.za, join the WhatsApp groups, and stay in the loop of the what's what and the who's who and the when's when in terms of family law in South Africa. So from myself, Mervyn, and from Nadia, who was supporting me all the way in the background while we were running today's presentation, we thank you for attending the Family Law Roundup, May 2024, and we look forward to seeing you for the next Family Law Roundup, which will be taking place on the, if my arithmetic is correct, but on the 5th of July, which is the first Friday of July. Registration details will be going out a little bit later today. Thanks for attending, and I will see all of you on WhatsApp land. From myself and Nadia, have a wonderful weekend, keep warm, and we'll see you at the next one. Cheers.